All right, our next story comes from Dark Reading, and the title here is "New HIPAA Cybersecurity Rules Pull No Punches." So in the U.S. here, I think everybody, even outside of the U.S., is probably familiar with HIPAA. HIPAA was published back in 1996, and it was last updated in early 2013, so like 11 years ago. And realistically, the HIPAA law initially was very much focused on privacy. It was to help enable a move to electronic health records. And so it was very focused on privacy, not necessarily focused on security. And when you look under the covers, I had a lot of experience with HIPAA in my prior life. There's a lot to not like about it, at least from a security perspective, because a lot of the nuts and bolts of what's in HIPAA were considered addressable requirements. And by addressable, it's kind of like optional. It was probably oversimplifying it to a fault. So if you're, screaming at your radio right now, stand down a little bit. But what these new updates do is both expand the scope of what HIPAA will require, but also remove some of that subjectivity. So that I don't know if it's everywhere, but they are largely getting rid of the concept of addressable requirements. So by the way, these requirements, the new proposed set of rules, are being published in the Federal Register tomorrow, actually, on January 6th. And there'll be, I think it's a 60-day comment period. And then that will get turned into a final set of rules. That, by the way, is a little unclear because there's going to be a change in administration. It's very unclear exactly when this will see the light of day. But after the new rules are published, there'll be a 6-month phase-in period. So it's conceivable that the new rules go into place by the end of the year. I'm a little skeptical, just based on my past experience. And by the way, the set of rules right now is about 400 pages. So it's a fairly weighty set, but there is a good summary linked from this particular story. And I'll just kind of read through the summary. One is that all of your policies, procedures, plans, and analysis will need to be documented in writing. You'll have to have a documented incident response plan with an ability to restore your information systems and data within 72 hours, which is interesting because a lot of the existing programs, compliance laws, and regulations require you to disclose within 72 hours. This is saying you have to have things back up and running within 72 hours, which makes sense, but it makes sense in the context of healthcare. Like I can't disagree, but it is aggressive. And we'll get to that in a minute. Asset inventory, you have to have an asset inventory, a network map to be able to track the flow of PHI through your environment. You have to perform a risk assessment, written risk assessments, additional security controls like multi-factor authentication. PHI has to be, protected health information has to be encrypted, both in transit and at rest. Those were, by the way, addressable controls in the past. You have to have... go ahead.
Can we riff on that for a second? Addressable controls, because we've used that term a few times, and I think what that means is, I don't use the word optional, but there seemed like there were different layers of HIPAA requirements based on the size of your practice. And what we're saying is that that's going away. Now, these are requirements across the board. If you're a one-man shop, or as they use in the article, a large East Coast hospital, now there's no longer a concept of, if you're a small shop, certain things weren't required. Everything's going to be required across the board now.
Yeah, everything's going to be required everywhere. The concept of addressable was on a couple different dimensions. One was based on size, but also I think more to the point, based on attributes of your environment. Like my network doesn't have any exposure to the internet, therefore I don't need encryption.
Got it.
And so therefore I don't need it. So just to carry on for that, I'm going to be releasing the conversation we had with Martin Fisher, who was the CISO of a hospital network here in the Atlanta area. And we had a good discussion with him about security in healthcare. And it's a different world, right? Because the kinds of technology you have to work with are a limiting factor. Like you're constrained by the environment that you have to work within. You're constrained by the reality of what you're trying to accomplish. Your mission is to keep people alive. And so it is going to be very interesting, because as I read it, at least on its surface, the objectives of this, like in calling some things non-addressable, seems to be at odds with the reality on the ground. And I'm not talking about necessarily like cost or convenience. Like I don't know, but especially when I reflect on the discussion we had with Martin, how some of these will actually work, because the technology may just not be compatible, and
So it may be at odds with ease of patient care or best patient care.
Exactly.
Yeah. And one thing they call out in here too is that for these small organizations, there will be a substantial cost that likely will be passed along to consumers as well.
Which is an amazing thing, given the amount that healthcare costs in the U.S. already. The current administration is saying that they expect this set of changes to cost about $9 billion collectively in the first year, and then I think dropping to $6 billion per year after that, which, I mean, it's a lot of money, but that's amortized across probably tens or hundreds of thousands of different medical practices across the U.S.
Right. So you mentioned this conversation with Martin Fisher. Where might someone find that when it's published?
Tomorrow, but which will probably by the time most people listen to this, it'll be it'll already be out. But you can get it at Getting Defensive.
So that would be our companion podcast where we interview industry leaders.
That's right.
On the Getting, and you could find that on, I think, every major podcast app and YouTube.
Correct.
Shameless plug.
It's an awesome podcast, if I do say so myself. And by the way, that was a particularly good discussion too. Martin is a good human.
He is. He recently retired or it's kind of wrapped up a long time as a healthcare CISO. So he has seen some things, and he has certainly put in his time. Anyway, check it out. It's a good discussion. So that'll go out tomorrow, January 6th. Got it.
Yes.
So thus ends my shameless plug. Back to your story.
So we'll know more after the proposed rulemaking has been out for a little bit. Again, it'll almost certainly not materialize as something we have to worry about till the end of the year. But we don't really know. My guess is, especially in the U.S., there's a lot of
lobbying,
I guess is the way I'll describe it. There'll be a lot of input from industry. It'll be interesting to see how much of that is taken up by the Department of Health and Human Services as they reshape this regulation. And we know that the new administration has I think a very different philosophy on regulation, although perhaps not in this area. So I don't want to presuppose anything. I think we'll have to kind of wait and see. But it is, I think, beyond time. Although I will say, stumbling over my words here, one of the frustrations I have is that we have yet another effectively cyber requirement, right? And when you look across, we have we have rules coming out from the Securities and Exchange Commission and from the FFIC for banks. And now we have rules coming out of CISA for critical infrastructure companies and on and on and on. And they're effectively trying to do a lot of the same things. There's huge amounts of overlap. I hope personally that at some point we start to see a bit of rationalization across, because again, a lot of these are trying to accomplish the same mission. There's some nuance. Obviously, the things in healthcare, like what matters in healthcare is different than what matters in, let's say, critical infrastructure or banking, right? There things that matter most are a bit different, but the things that you have to do tend to be very similar. And so I see a lot of opportunity for some harmonization, which I think would create some some scale, some efficiencies for compliance and whatnot.
Yeah, I think that's fair. I also want to kind of riff off one thing I saw in the article too. They were quoting Errol Weiss, hopefully I got the name right, Chief Information Security Officer at the Healthcare Information Sharing and Analysis Center, the Health ISAC. And he mentioned that what typically has happened and what he thinks will continue to happen is that instead of organizations using these HIPAA recommendations or as a baseline for developing a robust security posture, organizations tend to treat HIPAA more as a set of boxes to check, quote, and end up driving budget towards compliance, not necessarily security. And that is absolutely something I saw repeatedly in the banking industry with PCI. If you were, people would go up to what PCI said they had to do and not an inch further. And that I think can be an unintended bad consequence. So then you end up mandating security through regulatory action, which is usually very behind the state, excuse me, of the bad actors. So it's not great. The other thing that's interesting is the Supreme Court struck down the Chevron doctrine last year, which in many ways is what gave the power to these various organizations to pass, in essence, laws, which, I'm certainly not a lawyer, but my, rudimentary understanding is that with the Chevron doctrine gone, these various organizations that are impacted by this rulemaking authority of these various departments can challenge it now, saying, no, this should go to Congress to pass a law through Congress. And we don't recognize the authority of the power of law being mandated by this organization. That's my very loose understanding. So I wouldn't be surprised if you see a decent amount of lawsuits challenging some of these regulations as another avenue for those who don't want the burden of these regulations to appear.
We certainly see that starting to happen. Most recently, there was one within the past week about net neutrality. But I don't know the answer to this one, by the way. So my understanding of that ruling, I forget the name right now of the Supreme Court case that overturned the Chevron doctrine. It basically says that the agencies can't just take up the mantle and kind of backfill prescription. They can't prescribe what regulations mean outside of what Congress has said. But Congress can explicitly say in a law that, for example, Health and Human Services is responsible for determining what it means to comply with HIPAA. And if that's the case, then what the Supreme Court did with the Chevron doctrine doesn't apply. Now, I don't know if I'm not that familiar with the actual content of the HIPAA law itself, but it could be that it says that Health and Human Services is deputized to do that. And if that's the case, then that ruling doesn't apply. But if it doesn't, then you're correct.
So what we're saying is we're dangerously ill-informed on something we're commenting on. That's what it really comes down to. We don't know what we're talking about at all. We're just
I depending on how this comes out and depending on how much it costs, we probably will see lawsuits either way. So we'll see how that plays out. But my guess is we're not going to know a lot until, again, either later this year or this time next year. So, more to come, but it's overdue. However this lands, the protections that we have in the US are way behind on healthcare information. And as you pointed out, based on the comments from the CISO of Health ISAC, this is the bar that a lot of organizations are using. And that's just, it's not sufficient in the modern world. It just isn't. And so something has to change. The other thought that I had was very interesting. I was very involved in the early days of the rollout of GDPR in a big company and industry wide. One of the net effects of GDPR was creating this role of a data protection officer in organizations, because you had to have, like, it's in the GDPR rule that you have to have a data protection officer, and it created this like whole new like job market for data protection officers. And they didn't
just appoint a random executive admin or secretary to be that person.
Well, I'm not going to say that hasn't happened. I won't go that far, but I think what we saw, because there's a lot of small organizations. Like, you can't, if you're a flower shop and it has online ordering, like, you can't employ a dedicated data protection officer. But you don't need to either, and so it's created a market for fractional data protection officers, and at the very end of this article, it does point out that this is likely to drive a lot of, especially the smaller healthcare organizations, to involve or engage their own CISO, like called virtual CISOs or fractional CISOs. So I'm kind of seeing, although it's not necessarily explicitly written into the proposed rulemaking for HIPAA, it feels like it could have the same net effect of what GDPR did.
Yeah, could be. Or are you looking for some virtual CISO gigs? Is that what you're saying, Jerry?
Yeah, I was exactly where I was going. Like, as somebody who's recently unemployed and formerly a CISO, like, hey, like, this is a good opportunity for me.
And
for
you
me.
could say, virtually, you're a CISO.
Yes, virtually.
It'll be interesting to watch. And to be clear, by the way, I'm not against healthcare security. I could tell maybe my earlier comments might have come across as I was a little anti. I think my concern is that when you wrap a regulation or a legislation around it, it's usually very slow to be responsive to current threat. And we see, like you said, over and over in this particular discussion, when you've got this sort of regulation, businesses use that as the line, and they typically don't go further. That's the unintended consequence that I fear.
I think so. What would be interesting, and I think GDPR tried to do it a little bit, and they didn't do a very good job of it, in Jerry's unvarnished opinion, is to somewhat legislate that concept, right? That there isn't a bar. Like, you need to figure out what's appropriate and then do that, which is sensible.
Which drives, but that drives executives and lawyers crazy.
I know it does. It really does, because there's no safe harbor. It is kind of like, if something bad happens, you didn't do enough, and therefore you broke the law, and that causes untold consternation. But at the same time, what's the counter? What's the contra, right? The contra is you end up with something that's prescriptive and lags the threat landscape and doesn't properly protect you. And more mature and sophisticated organizations, sure, they'll do a better job, but that's not universally true. I mean, look at like how Change Healthcare. They hit a huge outage, and among the largest in the world. So it's not necessarily a function of size. At the same time, like a small family practice, local single office family practice is not, is not going to, on their own, going to go and employ a CISO to figure out what kind of security they should have. It's maybe some will, but I think the majority won't.
Yeah. It's an interesting world. And I'm sure there are trade groups and things like whatever these small healthcare association newsletter is. I'm sure they talk about this stuff and, have little sections on that. But
I do think pragmatically too, because we see a similar thing in banking. Like, large banks run their own IT. Like, really large banks run their own IT. Everybody else contracts with like Jack Henry or Fiserv or what have you. I think this is going to drive a similar kind of thing where it's no longer going to be feasible for healthcare providers to do their own IT. I mean, unless you're like a really large company, I think you're going to end up having to go with some kind of a hosted system. So anyway, enough pontificating on crap that we don't understand.
Well, if that's the rule, we should just shut the show down right now. We're done.
Okay, on that particular topic. Now we're going to pontificate on other stuff that we don't know about.